आगे कौन है सर? सर एक्सप्लोसिव एक्सपायर सर बहुत दरबार है सर
Sir, ready?
Yes, sir. Yes, sir. I won't take more than about 20 minutes or so. I don't want to repeat anything, and I'm conscious that I'm in rejoinder, so I should not re-argue issues anymore. So I'm only trying to rejoin only to what was argued by Mr. Dave, and just 2 or 3 small things, and I will close. One of the points that Mr. Dave made, they are minor points. I don't think he really meant them very seriously. But he made a point that defendants 2, 3, and 4 did not file affidavits in the trial court opposing the interim application. Yeah. So he says, how can they oppose it if they don't file affidavits? Now, with great respect, I don't know where in the Civil Procedure Code it is stated that if I don't file an affidavit, I can't oppose an interim application. The application, I can certainly oppose on saying that on the facts and documents you have disclosed, there is no case. I don't have to file an affidavit. An affidavit is only to bring some fact on record, which is not there. But if all the documents are there on record, I can say that don't. And in any event, 2, 3, and 4 appeared and argued and said that we are adopting the affidavit which has been filed by D1, which is now the appellant. And they are argued and put forward their respective positions. So I don't know what is the point of saying you didn't file an affidavit. I don't see what is the consequence of that. It's a non sequitur. This other thing that he also mentioned is that 2, 3, and 4 have not filed individual appeals. Now, again, I completely failed to see the significance of that. Because with great respect, sir, if the appellant has filed it, D1 has filed an appeal, we are supporting respondents. It is not, being a supporting respondent is not an uncommon action. So we are supporting the appellant. And then instead of burdening the court with filing 4 identical appeals, saying the same thing 4 times, one appeal has been filed and the others are supporting the appellant. Again, I don't see what is the issue, what is the sequitur to saying that you have not filed an appeal. Therefore, what? So these 2 minor issues. Just one more thing I want to just emphasize. I am appearing for D2. Now, why has D2 been made a party at all to this suit? The only reason D2 is made a party is, if your lordship is kind enough to look at the suit itself, which was filed, you'll just look at the suit for 1 minute. It's a page, the relevant page is page 506, paragraph 6.
Page 506.
506, sir. If your lordship is kind enough to see paragraph 6 of the plaint. It says, defendant 2 is Huber Group India, a subsidiary of MHM. It is involved in manufacturing of printing inks, dominant force in Indian printing industry, etc. and operates production facilities in Vapi, Daman and Silvassa. It is a direct subsidiary of one and was therefore sought to be acquired by plaintiff company as part of the Huber Group. Defendant 3 and 4 are shareholders. Now, I have pointed out 3 and 4 are not shareholders. That's a false statement made to their knowledge, but that's a different matter. As far as D2 is concerned, he says you are a subsidiary of D1 and you have a production facility in Vapi. This is D1, D2, sorry, D2. And then if you turn to page 528, paragraph 65, he says this honorable court has territorial jurisdiction to entertain the present suit because D2 has its office situated at plot so-and-so Vapi within the jurisdiction of the honorable court. And then he also says territorial jurisdiction cause of action has also accrued to the plaintiff within the ordinary territorial jurisdiction as parties have conducted multiple plant, factory visits and meetings. Now, with great respect, my lord, conducting multiple meetings at a particular place does not confer territorial jurisdiction. And that is, I think, to even suggest such a thing, my lord, is unreasonable. And for the learned judge to have accepted it was certainly capricious, arbitrary, unjudicious, and unreasonable. So, therefore, the only thing we are left with then is that you have that defendant 2 is a subsidiary and it has production facilities at Vapi. Now, just 1 minute. Let's just examine this proposition. Tata Sons is a holding company where the Tatas control the company. Tata Sons has a controlling stake in a number of subsidiaries. They have a stake in, they have a controlling stake Indian Hotels, which owns all the Taj hotels. It has an interest in Tata Chemicals, which manufactures chemicals. Now, it has also half a dozen other Tata companies. But let us just take, for example, these 2 companies, subsidiaries. Indian Hotels has hotels across the country and across the world. It has a hotel in Ahmedabad. Does Ahmedabad therefore get jurisdiction? If supposing I were to buy shares of Tata Sons, the holding company, which is situated in Mumbai, can somebody sue and try to prevent that transaction by saying that Tata Sons has a subsidiary Indian Hotels, Indian Hotels has one hotel in Ahmedabad, so I will go to the Gujarat High Court? Or somebody else will say that Tata Sons has Indian Hotels, Indian Hotels has one hotel in Taj in Calcutta, Taj, Bengal. Can he go to the Calcutta High Court? Take another example. Tata Sons also has a subsidiary, Tata Chemicals, which has a production facility in Gujarat. Can it therefore say that therefore now I will sue Tata Sons shares are being sold. I will sue them now in Gujarat because it has one subsidiary, Tata Chemicals, which subsidiary has its headquarters in Gujarat. So I will sue in Gujarat. But this is not how you can get jurisdiction. The cause of action is sale of shares. For as far as sale of shares is concerned, jurisdiction always, and this is invariable, has to be where the company has its registered office. Company which is the subject matter of the shares being sold, which in this case is MHM Holding. MHM Holding is a German company situated in Germany. The shares are held by German shareholders in Germany. If you want to sue, you have to sue in Germany. This is according to Indian law. Forget German law. Even Indian law will say you have to go to the place where the shares are located, which is always the registered office of the company. Not that the company whose shares are being acquired happens to have many subsidiaries, one of which happens to be in India, which has a production facility in the Vapi. Therefore, Vapi court has got jurisdiction. This itself is a complete perversion of any concept of law. So on every count that we look at, choice of law, German law, perversion, a perverts order which says, I will not even consider German law. I won't even mention German law, and I won't even tell you why I'm not going to look at German law. That is perverse. Territorial jurisdiction, non-existent. To imagine a jurisdiction on this completely convoluted and totally illegal way is capricious. It is not judicious. It is a non-application of a judicial discretion. Because when it says that an interim order is a discretionary order, discretion has always got to be exercised judiciously. A non-judicious exercise of discretion is automatically perverse. Your Lordship remembers the words used in the judgment of Justice Pardiwala, which my learned friend also relied on. Your Lordship saw that judgment. Where the learned judge categorically says, in paragraph 35, the first sentence which I read out, where before it explains the meanings of the various words perverse, any order made in conscious violation of pleading and law is a perverse order. Conscious violation of law. This is a conscious violation of law. It's a perverse order. So it is a perverse order qua law, perverse order qua jurisdiction. It's a perverse order qua a contract having come into existence, which I've already argued. It's a perverse order on every single count. And a perverse order, with great respect, my lord, not only can be set aside by your lordship, but must be set aside by your lordship. Your lordship doesn't just have a jurisdiction to set aside the order. With the greatest of respect, your lordship has a duty to set aside such an order. Because not to set aside a perverse order would itself be perverse. When something perverse is being done and has come before you, it is the duty of the court to say, I will stop that which is perverse. I will ensure that the rule of law, I will ensure the rules of justice will prevail and perverse orders shall not stand. That is the duty of a court. So a court would be in error, any court would be in error if it said that there is a perverse order, but I will allow it to stand. When it says it's an exercise of judicial discretion, what it contemplates is that there are two equally possible views. There are two reasonable views. Both views are reasonable. It is reasonable to say that this law applies. It is reasonable to say this law applies. The court has considered, given reasons why one particular should apply. Then you say, well, okay, I may disagree with that reason, but it's still a reasonable view. I'll allow it to stand. But when there is a complete disregard of the pleadings which say that German law applies, a disregard of the law which says that German law applies, and not only disregard, but a refusal to even consider and give any reason for it, then that is unreasonable. That is perverse. And perversity should never stand. And it is extremely important, my lord, that your lordship at this stage interferes immediately. Because to allow a perverse order to stand even for a day is to perpetuate injustice and perversity. And such perpetuation of injustice and perversity is not something which any court should ever countenance. Finally, Mr. Dave suggested that even if you think this order is wrong, set it aside in appeal, but don't touch it just now. So now you've heard everything. I have made out a case which I respectfully submit is strong enough to say that this order is perverse and should be set aside completely. So he says, okay, put it for appeal, hear the appeal, and then set it aside, but just now let it stand. Don't stay the order. Just now you're hearing stay, so don't stay the order. Now, if I have made out a good enough case to have this order set aside and buried deep in the earth and never come out, then why should it not, at least the very minimum would be that you stop and say, I stay the order today. It cannot continue for a minute longer. So you say, I make out a good case to say that set aside the order, but he says, doesn't matter. Even though it's a good case to set aside the order, don't do it today. Do it on some other day. Right now, let it stand. Though it is perverse. Once I've established that it's a perverse order, it must be stayed forthwith. I mean, what I cannot but end by pressing the point, my lord, that this is a matter which has grave repercussions on international commerce in India. Whenever such orders are allowed to stand, commercial entities across the world look with suspicion on any jurisdiction which allows such orders to continue. They then start wondering that, oh, is it risky to do business in India? I've actually known cases where banks abroad, because of certain judgments, had at one stage insisted we will charge a special risk premium to do business in India. Fortunately, that has now been overcome with as things have grown and as we have made sure that our laws and our judgments now conform with international norms. Now, this is something that is very important. Public interest, so whether it is my interest or public interest, it must be stayed forthwith. And once again, I would like to just bring to my Lord's attention and for your Lordship's very kind consideration that there is grave urgency in this matter, that I have been, that if every day that this order continues puts me in incredible prejudice, because as your Lordship knows, by 31st March, I have to close out this transaction before the financial year ends. I have to make payments to the banks before the financial year ends. Otherwise, grave consequences can follow. Now, the plaintiff knows this. So it is every attempt he has made to try and ensure that it doesn't get completed before 31st March. And therefore, I beseech your Lordship to have this matter concluded substantially before 31st March so that I have some time to complete and close out the transaction before 31st March. And this is my respectful submission to the court. I therefore submit that this order should be stayed as soon as it can possibly be stayed immediately. And Mr. Soparkar, I think was here. I saw him a minute ago. I don't know whether he's still online.
So Mr. Soparkar will start at 2:30, 2:45, subject to convenience of the court.
Please.
Sir, after Mr. Soparkar completes, I would like to seek your Honor's permission for about 15 minutes to make some clarification, because I would like to deal with a couple of points with Mr. Cooper has canvassed, which in my respectful submission are coming out blowing the rejoinder. And sir, after Mr. Soparkar completes, I would like to seek your Honor's permission for about 15 minutes to make some clarification, because I would like to deal with a couple of points with Mr.
It's up to your Lordship, but I submit that after a rejoinder, sir rejoinder should not in.
No, I'm thinking. I'm saying ordinarily,
otherwise this will be endless.
No, sir. Ordinarily,
he wants to say anything. Let him put it in writing and
submit it. But Mr. Cooper has in his rejoinder, he has dealt with some new points.
I've dealt with everything that has been argued. I have not gone outside your arguments.
I'm subject to your Honor's permission. I would like to assist your Honor by clarifying on certain issues where meat has been created. I would like to
I don't think this is up. I submit this is not appropriate. My learned friend wants to put in some.
Sir, I would
put it in by end of day.
I'll not take more than a 15 minutes, sir.
Yes.
On certain issues, the meat has been created with profound respect, which needs to be exploded. So on certain issues, which are not there on the record, a meat has been created before your Honor. I need to export that meat.
I must say, I think he has argued only on the legal points.
I will not take more than 10 minutes, sir.
I've been deliberately very, very careful not to step outside the bounds of a rejoinder. I've stuck to only what he has argued and I've dealt with each argument. I have not stepped out. I have not made a single new argument.
Sir, on certain, for example, sir, he has referred to the plaint, try to show that where we have pleaded, all these things that are coming for the first time. I need to point out that, sir. I leave it to your Honor. If your Honor grants me a permission, I will not take more than 10 minutes, sir. So there is no hard and fast
I
rule
strongly
that there
I
cannot be
would
a rejoinder
strongly
of sir
oppose this.
rejoinder, sir.
I would strongly oppose this, but it's in your lordship's hands.
I am in your honor's hands, sir.
No, anything.
Let Mr. Soparkar complete. Thereafter, if time permits, I would like to make. Sir, at 2:30 now, at 2:45.
Soparkar was here, no, earlier. Sir,
He wants at 2:45, sir, as I understand. Someone made a mention on his behalf.
એ એટલું મેન્શન કરવા જ આવ્યા હતા સાહેબ કે 2:30 ના આવી જશે.
If he had said so yesterday also, so in fairness, I must say he had.
So at 2:45, sir, now.
Okay.
Because 2:45.
2:40.
2:40.
By 3:30, we will conclude this matter today.
Yes, Manoj. Yes. Please, madam.
And
I'm
we'll
much
put it for
obliged.
order.
Lord. Your lordship has been very patient with us.
Yes, we are highly obliged for the patient hearing. It is always reason to argue when the honorable court is giving us the time to present our submissions, which we often find it, because Cooper may agree with me or not, maybe in the high courts we are often curtailed.
We are happy to hear you all. Sir, 2:45 we will get in touch.
2:40.
Yes,
Please, madam.
2:45,
My lord.
sure.
Obliged.
So, પ્રજાપતિ ચરણ આવ્યા છે મને
સંજયભાઈ,
investigating officers.
નહીં સાહેબ, સાક્ષી છે ને.
Sir, maybe leave.
Yes, 2:45 will join.
Yes, yes.
Explosive substance માં છે ને.
હા,
ક્યાં 23 છે ને. કોણ છે? રૂકેશભાઈ, પ્રકાશભાઈ. રૂકેશભાઈ, ગુલાબભાઈ બંને છે ને.
બસ.
Haji. Sanjay Ram Flower.
What did he
45.
Yes, I.
No, yes, sir.
Okay.
Valsad roller position. Overall, Valsad.
સંજયભાઈ, સવારે ફોટો વગેરે ભગવાન.
Photo over Bhagwan.
કઈ જગ્યાએ તમે સર્ચ કરતા ભાઈ?
તારીખ 17/11/2021. Police Sub Inspector Amiraj Singh J. Rana. Amiraj Singh J. Rana. तथा ASI चंदुभाई सुरपाल भाई. चंदुभाई सुरपाल
સંજયભાઈ, સુરપાલભાઈ.
सुरपाल तथा तथा LR Poco LR Police Constable Mayur Singh Kanak Singh LR Police Constable Anaramni LR Lokraksak Mayur Singh Kanak Singh
મયુરસિંહ
મયુરસિંહ કનકસિંહ નાવ સાથે ખાનગી વાહનમાં વલસાડ રૂરલ પોલીસ સ્ટેશન હદ વિસ્તારમાં પેટ્રોલિંગમાં હતા. તે દરમિયાન ફરતા ફરતા મોજે રોણવેલ થી વલસાડ તરફ ના રોડ ઉપર જતા હતા. તે દરમિયાન કલાક 18-15 વાગે ના અરસામાં એક બજાજ કંપનીની કાળા કલરની પલ્સર મોટરસાયકલ નંબર GJ15 DG 0874 નો ચાલક રોડની ધરમપુરથી વલસાડ તરફ જતો હોય જેના ઉપર કોઈ ગુનાહિત ચીજ વસ્તુ હોવાનો શક જતા તેને ઇશારા વડે રોડની સાઈડ પર ઉભો રહેવા કહેતા તેમણે તેની મોટરસાયકલ ધીમી કરી તેમજ થોડી વારમાં જ અચાનક તેમની મોટરસાયકલ વલસાડ તરફ પૂર ઝડપે હંકારવા લાગતા તેનો ખાનગી વાહન દ્વારા પીછો ચાલુ રાખેલ અને તેને ઉભો રહેવા બૂમો મારતા હોય પરંતુ ઉભો રહેલ નહીં અને મોજે બોમાપારડી બસ સ્ટેન્ડ પહેલા 100 મીટર પહેલા બોમાપારડી બસ સ્ટેન્ડ થી 100 મીટર પહેલા તેણે પોતાની મોટરસાયકલ રોડ ઉપર ઉભી રાખી ભાગવા લાગતા તેનો અમો તથા સ્ટાફના માણસો દોડી જઈ પીછો કરતા રોડની બાજુમાં આંબાવાડી તથા ઝાડી જંગલમાં નાસી ગયેલ જેથી મોટરસાયકલ પાસે આવતા પ્રથમ દ્રષ્ટિએ કોઈ ગુનાહિત જણાયેલ નહીં પરંતુ મોટરસાયકલમાં ઝીણવટપૂર્વક જોતા મોટરસાયકલની સીટમાં કઈ છુપાવેલ હોવાનું જણાતા સાથેના પોસ્ટ સબ ઇન્સ મીરાસિંહ રાણા ના હોય 2 પંચોના માણસો એમાં પંચ એક દયારામ ધનુભાઈ માંગેલા તથા 2 કિશોરભાઈ કુશાલભાઈ ચૌહાણ ભાવને બોલાવી સદર બનાવ બાબતે સમજ કરી મોટરસાયકલની સીટ ખોલી જોતા જેમાં પ્લાસ્ટિકની થેલીઓમાં વિસ્ફોટક પદાર્થ હોવાનું જેમાં ઇલેક્ટ્રિક તેમજ ઇલેક્ટ્રોનિક ડિટોનેટર હોય જે બહાર કાઢી જોતા આશરે 1.5 ઇંચ જેટલા ઇલેક્ટ્રોનિક ડિટોનેટર કેસરી કલરના વાયરો સાથેના અંદાજે 4 ફૂટ 6 ઇંચ જેટલી 4 ફૂટ 6 ઇંચ જેટલા નંગ બાર મળી આવેલ હોય જે એકની કિંમત ₹10 લેખે કુલ 12ની કિંમત ₹120 જેટલી ગણી તેમજ જિલેટિન સ્ટિક્સ નંગ 6 જે એકની કિંમત ₹60 લેખે કુલ 360 જેટલી નો વિસ્ફોટક પદાર્થ મળી આવતા જે ઇલેક્ટ્રોનિક ડિટોનેટર નંગ 12 એક પ્લાસ્ટિકના ડબ્બામાં તેમજ જિલેટિન સ્ટિક્સ નંગ 6 બીજા પ્લાસ્ટિકના ડબ્બામાં મૂકી કોશી શ્રી રવિરાજસિંહ રાણા નાવે સાથેના પંચોની સહીવાળી કાપલીઓ બાંધી વલસાડ પોસ્ટેના સીલના નમૂના વાળું લાગતી સીલ કરી મળી આવેલ વિસ્ફોટક પદાર્થો વિગતવાર પંચનામા કરી તપાસ અર્થે કબજે કરેલ હોય જે બાબતે સાથેના એએસઆઈ ચંદુભાઈ સુરપાલભાઈ નાવે સદર મોજા ચાલક વિરુદ્ધમાં ધોરણસર તપાસ થવા ફરિયાદ આપેલ છે. હા બાઇક કબજે કરી છે તેમજ તથા મોટરસાયકલ કિંમત સાહેબ સીલ કરવા પહેલા 24 સાઈડ સાઈડ જેટલી તેમજ જેટલી તેમજ મળી આવે બજાજ પલ્સર મોટરસાયકલ નંબર DJ 15 DG 0874 ની અંદાજિત કિંમત રૂપિયા 50,000 જેટલી ગણી
આરોપી નો ઓળખો છો આરોપીને પોલીસે મારો નિવેદન લીધેલું
જો સર ફરિયાદીને લીધા હતા સર કેસ બધું આવવાનું છે ખાલી ફરિયાદના જગ્યાએ નિવેદન કરવું
પચાસ વર્ષ
તરુણ કાટીલા ને કરી તરુણ કાટીલા
હા ઝડપથી 25
હા વાંધો નહીં.
સાહેબ સિરિયલ નંબર 7 ઉપર છે ડિલે અરજી છે
સવારના હાજર થવા માટે
આવી ગયા છે સાહેબ NM દેસાઈએ વકીલ પત્ર મૂકી દીધું
કેટલા દિવસ
78 78
વકીલ છે આનંદ દેસાઈ વકીલ છે આનંદ દેસાઈ
1-4 ભલે અને સાહેબ એક 12 નંબર ઉપર છે RNP માટે
अच्छा
8-4 જી સાહેબ
તમારે કયું કેમ ભાઈ
સિવિલ માં છે સાહેબ 2 નંબર પર કિમેલ લખાઈ ગયું છે
એક જણવાનું
વકીલ શ્રી કેમ પટેલ વકીલ શ્રી કેમ પટેલ રમેશભાઈ ગુલાબભાઈ
આવેલા છે. આમાં સાહેબ એપિયર થાઉં છું એમ. આમાં સાહેબ આ ઇન્ટ્રીમ ઓર્ડર પર સાહેબ આવ્યા છે લોકો 115 એ મુજબ સાહેબ, પણ એ સાહેબ ખોટી હાઈકોર્ટમાં જવું જોઈએ સાહેબ ઇન્ટ્રીમ ઓર્ડર ઉપર. નીચે રાઠોડ સાહેબ કોર્ટે સાહેબ 12 લાખ ભરવા માટે ઓર્ડર કરેલો સાહેબ ઇન્ટ્રીમ ઓર્ડર, પછી તમને ડિફરન્સ ના સાહેબ સમરી સૂટ હતો અને કન્ડિશનલ મંજૂર કર્યો 12 લાખ ભરો તો તમને ડિફેન્સ આપું બચાવ ઉતર. હવે એની સામે એમને અહીંયા આવવાના બદલે હાઈકોર્ટમાં જવાના બદલે સાહેબ અહીંયા ફાઇલ કરી છે રિવિઝન. જી આપી દઉં છું સર. સારું જી સારું. હું આજે આર્ગ્યુમેન્ટ જી સર મારું તો સાહેબ એટલું જ કે આ કોર્ટને સાહેબ હુકુમત નથી, મારું તો 115 મુજબ હાઈકોર્ટને સત્તા છે સાહેબ રિવિઝનમાં. આપી દીધું સાહેબ, appearance આપી દીધું છે. જી સર.
સિરિયલ નંબર 6 ઉપર બાદની કસ્ટડી મેળવવા માટે સાહેબ અરજી છે, તો એમાં સાહેબ અમારા અરજદારના પુરાવા માટે છે રિપોર્ટ આપું છું સાહેબ. એમાં જી સર. 10 દલીલ માટે છે. સર લિમિટેશન અને એમેન્ડમેન્ટ આપે. 10 નંબરમાં આવે તમે? હા 10 નંબરમાં. હા 10 નંબર. 10 વિશે કોણ? ને શું છું? મારી યાદ છે. એપ્લાય કરું છું. તમે શું આપો છો? હું તો દલીલ ક્લિયર છું, કારણ એટલા માટે ફાઇનલ દલીલ જ છે. જે રેકોર્ડ આવવાનો નહીં હતો નીચલી કોર્ટમાંથી, એના માટે સાહેબ નામદાર કોર્ટમાં જે પ્રોસેસ કરી અરજી આપી તો સાહેબ નીચેની નકલ મળે એવું દેખાતું નથી, એટલે સાહેબ ફાઇનલ આર્ગ્યુમેન્ટ કરી નાખવું પડશે. જી સર. કઈ વર્ષે ને એમ બી ઓર્ડરમાં
જી સર. 1 4 અને 4 થી 7 રિસ્પોન્ડ.
વારસો આવ્યા છે.
રિસીવ કરીશ. જોઈને પછી સાહેબ જવાબ એવું લાગે જવાબ આવડ્યું.
Copy agreement. Yeah, that.
जॉब पण
Yeah, that.
Yes.
जो आपने रिसीव करी ना,
जी सर करी
no objection लगे तो objection ना हो जाए,
जॉब पण साहेब जो जो सर
क्या चाह रहा
जी सर
serial number no final agreement sir.
Okay, sorry. Okay, sorry. अच्छा
तर मी सोल्व पण असली मोठी साहेब मुले
જી સાહેબ સર એપ્રિલમાં સોમ મંગળ સોમ બુધ
दोन सर एप्रिल महिना पहिली तारीख आपण सोमवार अथवा बुधवार तर 16/4
જી સાહેબ
Okay, PD देसाई. Okay, PD देसाई.
तुम्ही होतं गावाला
अच्छा
સિરિયલ નંબર 2 માં રિપ્લાય હું બહુ પછી આપી દઉં છું સાહેબમાં રિવિઝન રિપ્લાય આપી દઉં સાહેબ
सेवा
फिर 2 નંબર પર સાહેબ આ કોર્ટના
आपली पण आज
આજે આપી દઉં છે બહુ હાજી હાજી જી સર
टीवी पटेलने सीन करायला आपलं
જી સર
હું सीन करायला जाईल
હાજી
expected timeline and way forward. હવે આગળ કેવી રીતે વધવાનું છે પૂછે છે, કોન્ટ્રાક્ટ થઈ ગયા ની ક્યાં વાત કરે છે. In addition, as you are aware, we had requested for the below expert calls. Request if you can suggest time slots for this proposed experts call so we can align all advisors and freeze calendars. Text call, legal call. સાહેબ પેજ 309 ઉપર જ્યાં સુધી ચર્ચા પૂરી નહીં થાય સુધી આગળ નથી વધવાના. Kindly note that our SPA markup is final. Please let us know if you would like to share with your legal advisor so that they can review in parallel. Now, so this sentence is most important. Sir, તમે એ પહેલા એક અમારો મેલ જોશો તો અમે એમને એક ડિટેલ્ડ SPA મોકલાવ્યું. સર એ મેલ આપને પેજ 314 ઉપર મેં આપને બતાવ્યું એમાં છે. પેજ 314 ઉપર મેં આપને બતાવ્યું. Please find our attached counter markup. Could you honest look at first sentence? અને એ ડોક્યુમેન્ટ જે છે એ પેજ 316 થી ચાલુ થાય છે અને મેં ગયા વખતે આપને બતાવ્યું તો 316 થી માંડીને જે ડોક્યુમેન્ટ ચાલુ થાય છે એમાં ઓછામાં ઓછા 500 ફરક અમે કરેલા છે. એટલે એમણે અમને મોકલાવ્યું, અમે 500 ફરક કરીને મોકલાવ્યું, એક બે નહીં, ઇન્ક્લુડિંગ પ્રાઇસનું. હવે એ લોકો એમ કે છે, આ છેલ્લો મેલ જે વાંચ્યો મેં, કે ભાઈ તમે કહેતા હો તો આની સામે અમારા જે ફેરફારો છે એ ફેરફાર કરીને તમને મોકલી આપીએ. સર પ્લીઝ સી, હવે આ એંગલથી પેજ 415 જુઓ. સર આઈ એમ ટોલ્ડ સર કેટલા મેં 500 કયો ખોટું કહ્યું સર. પેજ 382 જુઓ તો એમાં કેટલા ચેન્જીસ દેખાય છે. આ સિસ્ટમની અંદર કેટલા ચેન્જીસ છે એ પણ ખબર પડે.
પેજ
382 સમરી રિપોર્ટ મળ્યો સાહેબ આપને?
યસ યસ.
લિટેરા કમ્પેર વર્ડ સાહેબ, એટલે પહેલો જે એમણે ડોક્યુમેન્ટ મોકલ્યો હતો અને મારા ડોક્યુમેન્ટમાં 1368 ફેરફાર છે. 651 વસ્તુ એડ થઈ છે, 686 વસ્તુ નીકળી ગઈ છે, નવા 26 ટેબલ ઇન્સર્ટ થયા છે, 5 ટેબલ નીકળી ગયા છે. કુલ 1368 અમેન્ડમેન્ટ અમે સજેસ્ટ કર્યા. આ અમે મોકલ્યો એમને. એનો જવાબ એમણે જે મોકલ્યો એ પેજ 415 ઉપર. ભાઈ કે અમારી પાસે પણ હવે નવો SPA તૈયાર છે, તમે કહો તો મોકલી આપીએ. Two things will fall. પેજ 415 સાહેબ છેલ્લી રીતે જોઈએ. Kindly find note our SPA markup is ready. Please let us know if you would like us to share with your legal advisors so that they can review in parallel. Two things. એટલે અમારો SPA એમને મંજૂર નથી, એટલે અમારો SPA તો એક્સેપ્ટ નથી થયો. એમનો SPA એમને મોકલ્યો જ નથી એટલે અમે મંજૂર કરવાના નથી. એટલે SPA અમારો એમને મંજૂર નથી, એમનો તો આવ્યો તો એમની ઓફિસમાં પડ્યો છે. અને પેજ 309 ઉપર એમ કહે છે જ્યાં સુધી SPA સહી નહીં થાય ત્યાં સુધી મારી ઓફર ગણવાની નહીં. કોણે એક્સેપ્ટ કરી, ક્યારે એક્સેપ્ટ કરી? સર આ વસ્તુ આ વાત થઈ 29 ઓક્ટોબરે. પછી 4 નવેમ્બરે અમે કહ્યું કે બીજા લોકો જોડે અમે ચર્ચા કરી છે, તમારી જોડે ચર્ચા અમે કરવા માંગતા નથી. પેજ 416 417 પર એમનો જવાબ જો બહુ ઇન્ટરેસ્ટિંગ છે. એમ કહેતા હોય કે સાહેબ આપણો તો એગ્રીમેન્ટ થઈ ગયો તો હવે તમે કેમ આવું કરો છો? એવું નથી. પ્લીઝ એમનો જવાબ. We are surprised to receive with your below mail. We have been in continuous touch with you over last 2 weeks with regard to finding ways to breach any gap in our last offer and the expected valuation. અહીંયા છેલ્લા 2 અઠવાડિયાથી અમે તમારી જોડે ચર્ચા કરીએ છીએ કે તમારી અપેક્ષા શું છે ને મારી ઓફર શું છે, એની વચ્ચે કે ડિફરન્સ સેટલ કરીએ. 4 નવેમ્બરે એમ કહે છે કે આપણે ચર્ચા કરી રહ્યા છીએ. માય ફ્રેન્ડ મિસ્ટર દવે વોન્ટ્સ ઓનરેબલ કોર્ટ ટુ બિલીવ કે 9મી સપ્ટેમ્બરની ઓફર એક્સેપ્ટ થઈ ગઈ હતી.
4 નવેમ્બર એમનો જ કાગળ છે કે ભાવમાં કઈ ફેરફાર છે. વી આર કન્ટિન્યુઅસલી been informed bank waiver process has been highly complicated and the trustees, the PwC team, their other advisors have been busy with the same. Interactions with all bidder has been stalled due to this and will resume this week. તબ છેલ્લું વાક્ય અગત્યનું છે. Interaction with all bidders. એટલે એમને ખબર છે કે અમે બીજા લોકો જોડે ચર્ચા કરી રહ્યા છીએ અને અમે ચર્ચા નથી કરતા. Based on the above, we were expecting feedback towards how we can quickly sign the deal. Sir, they are saying આપણે કેવી રીતે deal sign કરીએ. And my friend wants the honorable court to believe by oral understanding contract was concluded. Instead, we are surprised to hear that you have decided to focus on the transaction with other bidders. Sir, please see એક વસ્તુ. It is not their case that contract was આપણો execute થઈ ગયો, settle થઈ ગયો. હવે શેની વાત કરો છો? That is not their case at all. ચર્ચા અમે ભાવ વધારવા તૈયાર હતા, તમે કેમ વાત નથી કરતા અમારી જોડે, એવી વાત છે. સર, પેજ 418 પર અમે કહી દીધું કે સોરી, અમારે તમારી જોડે ડીલ નથી કરવી. 8મી નવેમ્બર એનો કોઈ જવાબ નથી. 13મી નવેમ્બરે પેજ 419 અમે કહી દીધું કે થર્ડ પાર્ટી જોડે અમારો એસપીએ પણ તૈયાર થઈ ગયું છે.
You have another offer and have signed SPA with the respective investor.
Another. એટલે 14 નવેમ્બરનો જવાબ જુઓ સાહેબ, પેજ 424. એમ નથી કહેતા કે અમારી તો ડીલ થઈ ગઈ, તમે બીજા લોકો જોડે કેમ ચર્ચા કરી. પ્લીઝ સી, એમ જ કહે છે કે અમને બ્રેક ફી આપવાની છે, બીજી કોઈ વાત નથી એમની. પેજ 424. We have received the bill of mail, noted the contents thereof. As you are aware, we have remained fully committed to the proposed transaction between Sellers and Jindal, which is evident from the fact we have, now please mark, we have periodically shared our offer and confirmation of proposed transaction with you, which were duly acknowledged and acted upon you. Pertinently, our last offer of 9 September was accepted and acted upon by you. On what basis they are saying this? Sir, એના 4 દિવસ, આ 14મી નવેમ્બરનો કાગળ છે અને 4 નવેમ્બર તો એમ કહે છે કે અમે ભાવ વધારવાની અમારી તૈયારી છે. Sir, at this stage, please kindly go back to page 417. અમે ભાવ વધારવા તૈયાર છે. એટલે 4 નવેમ્બરે કહે છે ભાવ વધારવા તૈયાર છે અને 14મી નવેમ્બર તો કહે છે કે 9મી સપ્ટેમ્બરનો એગ્રીમેન્ટ થઈ ગયો હતો. અને માંગે છે શું? Not that therefore you cannot enter into agreement, we want the agreement, specific performance. ખાલી 9 મિલિયન યુરો આપો, આટલી જ માંગણી છે એમની. સર, પેજ 425 એ 14મી નવેમ્બર અમે કહી દીધું કે આ શક્ય નથી, તમારા પોતાના મેલ જુઓ. તમારા, I'll read sir page 425. Your offer did not meet with our expectation. This was never accepted by us. On this point, you may want to refer to your own email of 4th November 24 and 17th October 24. Sir, a 4th November 24 નો email જે છે એ આપણે હમણાં જે જોયો એ 414 વાળો અને 17મી ઓક્ટોબરનો જે ઈમેલ જે છે એ પેલો લાંબો ઈમેલ આપણે જે જોયો.
The 425 you are informing them that your offer was never accepted by us.
Yes, sir. એટલે 408, 409, 4 નવેમ્બરનો 414 છે અને આ 409, 414 અને 414, 414 અને 409. Therefore, the whole case put up by them is factually incorrect. Therefore, my first respectful submission to the Honorable Court is that the whole case, that contract is concluded, we are entitled to specific performance, and therefore we are entitled to injunction, must fail on facts. Now let me deal with two legal issues dealt with by learned friend. One, but you cannot stay such an order pending the appeal. So the law is, I will take the Honorable Court into law in 2 minutes. If the Honorable Court wants to stay the prohibitory order at an interim stage, I need to cross a higher bar. I need to show something more than prima facie case. In my submission, we have shown more than conclusive case. આ correspondence થી પેજ 309 પર એ લોકો જો એમ કહેતા હોય કે જ્યાં સુધી સહી સિક્કા ના થાય ત્યાં સુધી અમારી કોઈ જવાબદારી નથી, સહી સિક્કા થયા ના હોય તો કોન્ટ્રાક્ટ કેવી રીતે થયો? 309 લખ્યા પછી તો ચર્ચા આટલી બધી થઈ છે. Whole contract here is completely bogus. If that is so, please see. There is a compilation of case law. I don't want to cite every judgment because most of them are cited by my learned friend, Mr. Cooper. I'll just take 2 or 3 small issues. So please go to first page 34. Relevant on page 35, para 10, Delhi High Court. Mohammad Shakil. Where a judgment or decree is injunctive in nature. That is where the judgment or decree injuncts either of the parties before the court from performing any particular act. Ordinarily, no stay orders of such an order can be sought, as it would mean to placing the clock back and restoring the status quo ante. More roughly expressed, a stay order cannot be stayed save in rare and exceptional cases, where restoration of status quo ante at an interrogatory stage is imperative in the interest of justice. એટલે આપની સત્તા ઉપર કોઈ બાધ નથી. There is no prohibition on the power of the court. Question is discretion. When would the Honorable Court exercise the discretion? If we have made out an exceptional case, a rare case, the Honorable Court would certainly stay this. So please see the next judgment, page number 37, Assam and Nagaland High Court Division Bench judgment. Please go to page 42, last line. The para 17 ની છેલ્લી લીટી. Appellate court has got full power to pass an order of stay of operation of an order appealed against in exercise of his discretion if it thinks that circumstances of the case demand a stay order. Order 41, Rule 5.3 will not in express terms apply to the case of stay of execution of decree. Apart from that, power contained under Order 41, Rule 5 may not be exhaustive in itself in any view of the matter. We do not think that when the court had jurisdiction to entertain the appeal, it had no jurisdiction to pass an interim order of stay. And this court under section 115 of the CPC will not interfere. It cannot be said that ex parte order passed by court below under Order 40 Rule 5 of the CPC is an order. So therefore, I have to make out a case, a special case. But to say that, sir, you will not have power will not be correct. So please see now page 59, Calcutta High Court judgment, 2005.
Development Corporation.
Yes, sir. Please go to page 63. So the argument is કે સાહેબ અત્યારે આપ તો રિલીફ આપશો તો મેઇન રિલીફ અત્યારે ઇન્ટરિમ સ્ટેજ પર કેવી રીતે અપાય અપીલના હિયરિંગ વખતે આપવી પડે. પ્લીઝ સી હાઉ ડઝ ધ કોર્ટ ડીલ વિથ ધીસ. પેજ 63, para 38. The other point on this basis of which learned judge has dismissed the application is that order sought for was in the nature of main relief by way of an interlocutory application. It is well settled that in given circumstances, court can always pass interim relief in the nature of final relief, though such power is required to be used sparingly and with utmost caution. But it cannot be contended that court is precluded from passing an order in an interlocutory application which would result in granting a final relief. એટલે again આપની સત્તા છે, ઉપયોગ કરવો કે નહીં નક્કી કરવાનું. The same view has been expressed in the decision of Woodford in English court. Before the court, the counsel for the defendant relied upon a passage of Supreme Court practice which reads as under, it is not the practice of this court to grant an interlocutory application an injunction which will have practical effect of granting the sole relief claim. This does not deter the court from granting such interlocutory injunction as may be necessary to preserve property or prevent irreparable. Now, sir, please see. Disagreeing with the aforesaid proposition, Justice Megari held there is nothing to prevent the court, please mark, nothing to prevent the court in proper case from granting on motion substantially all the reliefs claimed in the action. After discussing various judgments on the issue was held by Justice Megari that in a given case, court could indeed grant the final relief by way of an interlocutory order. Sir, please see further paragraph 53 on the next page. Page 64. In the decision of Indian Cable reported in 89 Calcutta Weekly Notes, a division bench of this court have also held that there is no bar, please mark, no bar in the matter of granting a relief in the final form if the circumstance of the case deserves such an order. In the instant case, as we have already observed, a decree passed against the respondent one has reached the stage of finality, shares have been sold until it is perfected, so and so and so would be rendered infructuous. That's on facts. And before I summarize this aspect, please go to the last judgment of the Honorable Supreme Court on the point, page 66, 2004, volume 4 SCC, page 697, relevant on page 72. So paragraph 12. Situations emerge where the granting of an interim relief would tantamount to granting the final relief itself. And then there may be converse cases where withholding an interim relief would tantamount to dismissal of the main petition itself. So, આપણા કેસમાં એ થશે, આપ જો interim relief નહીં આપો તો અમારી appeal dismiss થઈ ગઈ. For by the time main matter comes up for hearing, there will be nothing left to be allowed as relief to the petitioner, though all findings may be in his favor. In such cases, availability of a very strong prima facie case of a standard much higher than just prima facie case, consideration of the balance of convenience and irreparable injury, forcefully tilting the balance of the case totally in favor of applicant may persuade the court to grant an interim relief, though it amounts to granting the final relief itself. Of course, such would be a rare and exceptional case. Court would grant such an interim relief only if it is satisfied that withholding it, kindly mark, withholding of it would prick the conscience of the court and do violence to the sense of justice, resulting in injustice being perpetuated throughout the hearing. At the end, the court would not be able to vindicate the cause of justice. So this sentence of the Supreme Court is very important. आपने लागे कि जो relief नहीं आप्याती injustice થશે तो आपने पूरी सत्ता છે. To say કે आप relief ना આપી શકો, that's completely contrary to the Supreme Court judgment. Please see further. Obviously, such would be rare cases accompanied by compelling circumstances where the injury complained of is immediate and pressing, which causes extreme hardship. Conduct of the party shall also have to be seen, and the court may put the parties on such terms as may be prudent. Present is a case where we are fully satisfied that a foolproof case for the grant of interim relief was made out in favor of the petitioner in the High Court on the basis of material available to the High Court. Therefore, sir, I must satisfy the test of a foolproof case. What is the case of the plaintiff? Concluded contract. If there is no concluded contract, he will fail because there is thereafter nothing. If I can show that the whole theory of concluded contract is ex facie wrong, we have argued that more than once, including today in detail, then I have made out a foolproof case. In spite of that, if the Honorable Court does not give me relief, સાહેબ આપને 31 માર્ચની ડેડલાઇનની માહિતી અમે આપેલી છે, સામેવાળા પર ડિસ્પ્યુટ નથી કરતા. 31 માર્ચ પછી તો આપણી will become infructuous. Sir, ultimately, what other side is trying to say is, અમે પણ અપીલ ડિટેલમાં આર્ગ્યુ કરી, એમણે પણ ડિટેલમાં આર્ગ્યુ કરી, હવે બીજું કે આર્ગ્યુ કરવાનું રહેતું નથી. પણ don't treat it as hearing of appeal. Treat it as hearing of interim application so that Honorable Court can be persuaded not to pass the order. That is not the law, sir. Law does not prevent the Honorable Court from passing an order in a rare situation. This is one such rare situation. If order is not passed by 31st of March, we would be completely ruined. If order is passed, if plaintiff succeeds, Honorable Court will give appropriate decree at an appropriate time. It's going to be money decree. My respectful submission is the whole attempt on the part of plaintiff to prevent the Honorable Court from passing an order by raising an argument, sir, final relief cannot be granted at this stage, is devoid of any principle of law. Sir, the next 4 judgments I am not citing because my friend Mr. Cooper has already cited. Okay. Order 43, Rule 1 R interfere ના થવાય. In fact, એમનું એક જ જજમેન્ટ જે એમણે સાઇટ કર્યું છે, જસ્ટિસ પાડીવાલાનું છેલ્લું જજમેન્ટ. At this stage, please have a look at that last judgment of Justice Padiwala, which they have cited, sir. Please see that judgment. If the Honorable Court can pick up their compilation. I don't know whether it's compilation or they have given separately. Sir, Justice Padiwala judgment to show up. Honorable Court has it, sir?
Yes.
1 second, sir. Let me take out my copy.
Oh, party નામ?
એક જ સેકન્ડ આપને આપું, sir. સર પાર્ટીનું નામ છે one second. રમાકાંત અંબાલાલ ચોકસી.
રમાકાંત વાળું જજમેન્ટ ગઈકાલે દવે સરે સાઇટ કર્યું હતું તે વાળું એ લૂઝ આપતા હતા એક I think it was tendered at 5th in the sequence.
સર એમાં પેરેગ્રાફ 20 થી એપેલેટ જ્યુરિસ્ડિક્શન ચાલુ થાય છે.
રમાકાંત અંબાલાલ ચોકસી.
હા, પેરેગ્રાફ 24 થી when a court ignores relevant fact for case is made out for interfering with the discretion. The para 26 must have conclusion જોઈ લઈએ. પહેલું, what flows from a plain reading of the decision Evans and Charles is that an appellate court, while deciding an appeal against a discretionary order granting an interim injunction, has to A, examine whether the discretion has been properly exercised. That is, examine whether the discretion exercise is not arbitrary, capricious, contrary to principles of law. And in addition above, appellate court may in a given case have to adjudicate on facts even in such discretionary order. સાહેબ આપને એવું લાગે કે ટ્રાયલ કોર્ટનો ઓર્ડર આર્બિટ્રરી નથી, કેપ્રિશિયસ નથી, or contrary to principles of law નથી, ચોક્કસ અપીલ ડિસમિસ કરવી પડે. પણ આપને લાગે કે આર્બિટ્રરી, કેપ્રિશિયસ અને contrary to principles of law છે, then appeal or for that matter interim order requires to be accepted. Sir, page para 33 થી principles granting interim injunction discuss થયું છે.
Para 20.
The paragraph 33 થી
Principles governing grant of.
હા, but perversity અમારે ખાલી બે જ પેરેગ્રાફ વાંચવા છે. પેરેગ્રાફ 35 થી meaning of expression perverse. Any order made in conscious violation of pleading. Mr. Cooper had pointed out, shareholder પક્ષકાર નથી, એ વસ્તુ ચર્ચા થઈ છે, એ દલીલ થઈ છે. એ હિસાબે મને હુકમ આપી દઉં છું. એન્ડ લો કોન્ટ્રાક્ટ થયો જ ના હોય તો મને હુકમનો ક્યાં પ્રશ્ન ઉભો થાય? Is a perverse order. In Moffat, the court observed a perverse verdict may probably be defined as one that is not only against the weight of evidence, but is altogether against the evidence. Godfrey, court defined perverse as turning the wrong way, not right, distorted from the right, turned away, or deviating what is right, proper, correct, etc. So, para 36 definition જવા દી, ખાલી ફક્ત para 37. The wrong finding should stem from a complete misreading of the evidence, or it should be based on conjectures and surmises. સાહેબ કોન્ટ્રાક્ટ થઈ ગયો છે તો conjectures and surmises જ છે. So, મળ્યો આપણે para 37. Safest approach on perversity is the classic approach is on the reasonable man's inference of the facts. To him, if the conclusion of facts and evidence made by the court below is possible, there is no perversity. If not, finding is perverse. Inadequacy of evidence or a different reading of evidence is not perversity. સાહેબ સામાન્ય વ્યક્તિને એવું લાગે કે આ સંજોગમાં કોન્ટ્રાક્ટ થઈ ગયો છે તો ઓર્ડર પરવર્સ નથી. આપને એવું લાગે છે? My submission is the correspondence between the parties very clearly shows there is no contract. The whole bogey of contract is bogus. Therefore, sir, the Honorable Tribunal Court has a power, not only power to interfere finally, but also even in the interim stage. Then my learned friend raised another contention of res judicata. And his case was, as the issue raised under Order 7 Rule 10 is not challenged, I cannot maintain this appeal. There are, in my submission, this contention is fallacious both in fact and in law. Number one, sir, res judicata ક્યારે લાગુ પડે? When an issue is finally decided in a suit, it cannot be raised again. 711 અને exhibit 5 ના hearing માં એક fundamental ફરક છે. I'll immediately clarify and I'll take the honorable court to the law of the point. Sir, 711 has to be decided only on the basis of plaint, where defendant has nothing to do. Plaint and the documents of the plaint, whether the suit is maintainable or not. Defense of the defendant is not material. Whereas exhibit 5 is to be adjudicated on the basis of not only the plaint, but even the defense. Before I take the honorable court to the law, please see the order of trial court. Trial court has said, I am deciding it only on the basis of plaint. So please go to page 616. Order of the trial court, para 12, પહેલા જ પેરેગ્રાફમાં એમ કહે છે. એટલે મારો ડિફેન્સ તો જોવાનો પ્રશ્ન ઉભો નથી થતો એ તબક્કે. Heard both parties at length, it is settled principle of law while deciding application of 711 of the court. Averments made in the plaint in its entirety are to be considered by taking those averments to be correct. Plaint cannot be rejected on the basis of allegation made by the defendant in the written statement or application rejection of plaint. Court has to read the entire plaint as a whole to find out whether it disclosed or cause of action. If it does, plaint cannot be rejected by the court exercising power of 711. Essentially, whether the plaint discloses the cause of action is a question of fact which has to be gathered on the basis of averments made in the plaint in its entirety, taking those averments correct. what will be considered whether the plaintiff discloses in course of action. 711, the principle of whatever they have said is correct. Even if it is correct, whether the plaintiff is maintainable or not. My defense does not come into consideration for 711 at all. There were finding reached in 711 will have no bearing at the second stage when Exhibit 5 is being adjudicated, which is being adjudicated on merits after taking into consideration their case and my case. Please see a direct judgment on this issue. You have separated this. Sir, please go to judgment of us. There's one separate compilation. Saurabh Kalani, page 21.
Compilation D sir. અત્યારે મેં જે આપ્યું. જી.
એના પેરા 22 ઉપર.
Page 21.
It starts on page 21. I would request the Honorable Court to have a look at page 27. આ જ હતું 711 and Exhibit 5. Further, contention of the learned counsel for the petitioner that though DRAT while deciding appeal has permitted petitioner to move an application as to his grievance relating to limitation, and in case such application is moved, same shall be considered by the tribunal at the time of decision of the original application is concerned, is of no consequence, as the order passed by DRT rejecting application filed by petitioner under order 711 has held therein that the original application is not barred by limitation, has not been set as a DRAT. Same will operate as res judicata at the time when the issue of limitation will be considered as the direction of DRAT. Contention of learned counsel for the petition is also misconceived. Now, this is important. For the reason, at the time of consideration of application under order 711 of CPC, tribunal has to confine itself only to the affidavits made in the original application. And at that stage, tribunal cannot look into any other material while considering the issue of limitations that the DRAT. Tribunal has to examine pleadings of both parties as well as evidence laid in support of their case by both parties. In my view, any finding recorded by DRAT while deciding application of 711 will not operate as res judicata while deciding issue of limitation after action of pleading after parties have laid their evidence. Exactly what I am saying. 711 no stage judo che, Exhibit 5 no decision stage judo che. Sir, please also see judgment number 1 of this compilation, and there please go to paragraph 14, page number probably 9.
Just to point out that.
Sir, એમાં એ પેરેગ્રાફમાં છેલ્લી 5 લીટી જોઈએ. Sir, એમાં 9-7 રિજેક્ટ થઈ હતી ને પછી એ ઇશ્યુ ફરીવાર લેવાય કે ના લેવાય. The case of an application under order 9 rule 7 an illustration of this case. If an application made under the provision of that rule is dismissed, appeal were filed against the decree in the suit in which such application were made, there can be no doubt that the propriety of the order rejecting the reopening of proceeding Sir, મળ્યું આપને?
હા, મળી ગયો.
Sir, please see the next page, vigility thing. But ચોથી લીટી thing. But what we are concerned with is slightly different. And that whether the same court is finally bound by that order at a later stage so as to preclude it's being reconsidered. Even if the rule of res judicata does not apply, it would not follow that in every subsequent day with the suit stands adjourned for further hearing, petition could be repeated and fresh orders sought on the basis of identical facts. Principle that repeated application based on same facts and seeking the same relief might be disallowed by the court does not, however, necessarily rest on the principle of res judicata. Thus, if an application for the amendment of a suit is rejected, subsequent application for same purpose, even if based on the same fact, is not barred on the principle of a rule of res judicata, same is on the same ground on which original application was refused. Principle underlying a distinction rule of res judicata and rejection ground that no new facts have been adduced to justify different order is vital. Principle of res judicata is applicable to decision on a particular issue of fact. Even if fresh facts were placed before the court, bar would continue to operate and preclude a fresh investigation. Where is it true? So principle है कि I cannot on the same issue, on the same facts, or even new facts, argue the same issue before the same court. Res judicata cannot apply to proceeding before the appellate court. Sir, day in and day out, before the trial court, when the trial is conducted, various interim applications are filed. They are accepted or rejected. Every time party has not to rush to High Court to challenge it. As and when appeal is filed, he can take every proceeding in appeal. So there are two more angles. First, one more angle being issue of jurisdiction can always be raised. Please go to judgment on page 1930. Page 30, 1971 SCC 613. And within that, sir, please go to page number, probably the last page of the compilation. Page 30,
36.
page 36 last.
Yes.
A question relating to jurisdiction of a court cannot be deemed to have been finally determined by an erroneous decision of the court if by an erroneous interpretation of the statute, court finds it has no jurisdiction. Question would not, in our opinion, operate as res judicata. Similarly, by an erroneous decision of the court assumes jurisdiction which it does not possess under the statute, question cannot operate as res judicata between the same parties, whether the cause of action in subsequent litigation is the same or otherwise. Therefore, issue of jurisdiction will never be a subject matter of res judicata. Therefore, I have multiple answers to the argument of res judicata. Number one, jurisdiction will never be settled. Number two, it will not apply to appellate proceedings. Number three, 711 has nothing to do with the principle of res judicata. Number four, the scopes are different. Now, let me very quickly run through the other answers given by my learned friend. Sir, our first contention was shareholders are not a party, to which my friend Mr. Dave says, but in one publication, I have said defendant 3 is a shareholder. If defendant 3 is a shareholder, court can have a jurisdiction, if at all, against number 3. 4 is a party, it may have jurisdiction number against number 4, though we submit it. Court has no jurisdiction, but 3 and 4 are parties. Because plaintiffs are aware they are not the right shareholders. So when would the Honorable Court like me to close? I can close it in 10 minutes now, 15 minutes.
I'm sure citations are both the parties have cited a lot of judgments.
So let me summarize in 10 minutes.
Our main points tomorrow check there was no concluded contract.
So Maro, Pelu, court has no jurisdiction. Court had no jurisdiction because German court and German jurisdiction. My friend Mr. Dave says, આ clause પછીના કોન્ટ્રાક્ટમાં નથી. જર્મન લો તો છે જ, પણ નથી. સર, આ ટુ સ્ટેજ ડિસ્કશન છે. ફર્સ્ટ સ્ટેજમાં ઓફર મંગાવી, એ વખતે ટર્મ મૂકી, આ ટર્મ ઉપર તમારે ઓફર આપવાની છે, એમણે એક્સેપ્ટ કરી, એમાંની જે ટર્મ છે જર્મન લો અને જર્મન જ્યુરિસ્ડિક્શન. પછીની આખી વિધિ છે પહેલી ટર્મના પ્રમાણે નક્કી થાય છે. એટલે જર્મન લો અને જર્મન જ્યુરિસ્ડિક્શન અમારે ફરિયાદ રિપીટ ના કરવું પડે. ઇટ્સ અ પાર્ટ ઓફ ધ ફર્સ્ટ ડીલ. સો ફર્સ્ટ સબમિશન, this court has no jurisdiction. Second submission, shareholders not being parties, no injunction could have been given. If they believe 3 and 4 are shareholders, good enough. You don't need an injunction against shareholders. Third, no concluded contract. I have made detailed submission on this. Therefore, no prima facie case. Balance of convenience completely against us. If we lose, we will be completely destroyed. Whereas they have nothing to lose. At best, they will have money claim. And in any case, suppose they want the deal in their favor, the Honorable Court at an appropriate stage can always pass an order nullifying or reversing the transaction. Power of the court in any way is not affected. So balance of convenience is in our favor and against them. Irreparable loss also we have argued. Court has power to grant stay at an interim stage. Also, I have now made my submission. Res judicata principle does not apply. Therefore, let me now conclude, sir. We are immensely obliged for the Honorable Court for giving us a patient hearing. My submission is, sir, the Honorable Court has a choice either to grant interim relief, which in my submission, it would be in the ends of justice, or if the Honorable Court says, no, we will not grant interim relief for whatever reason, in our respectful submission, there will be great loss in law to the appellant, and the respondent number one, who has nothing to do with the matter, he has not spent 1 rupee, is today trying to hold up the transaction worth more than rupees 3,500 crore. He has no stake of even 1 rupee. This is purely a speculative litigation or an economic blackmail. Our respectful submission, as Mr. Cooper rightly said, this matter is sending wrong signal about our judicial system in foreign jurisdictions. That you can have negotiation, though contract is not concluded, there will be so stuck, you will be ruined, but in Indian courts, you will not get the justice. I would respectfully submit the fit case, Honorable Court may grant interim order. That's all, sir.
બોલો ધવલભાઈ તમારે કઈ
સાહેબ actually rejoinder further now happened. They also basically argued as if they are arguing for the first time instead of giving rejoinder to my reply. One thing, sir, which I would like to submit is that a lot was said that everything will be over by 31st of March. So this is nothing with profound respect of pressure tactics. There is nothing on the record to show that on 31st March 2025, if the order is not passed one way or other, they will be put to great difficulty. Nothing on the record. And sir, in my respectful submission, 31st March 2025, according to them, is a self-conceived date for completion of the transaction with other party. Sir, in my respectful submission, if I have established that I have a concluded contract to my favor, and sir, their contention, there was at first 31st March 2025, every time a deadline was shown to the Honorable Court during the course of the hearing without there being nothing on the record. Before the trial court, when we were insisting for urgent hearing, they were saying there is no element of urgency. Sir, all of a sudden, this 31st March 2025 date has cropped up in the hearing. Then, sir, lot was said by Mr. Cooper that if this matter is not done, not taken up immediately for hearing, if the orders are not passed, if these orders are permitted to hold the field, it would create a bad image internationally. In my respectful submission, these are the arguments meant on a political platform, sir. These are not the arguments to be advanced in a court of law. If I have a case, I have a case. Whether my counterpart is from Germany or from America, it is inconsequential. So, Honorable Court will never decide the outcome of the matter depending upon the profile of the defendant. So, what is to be seen is they are parties before the Honorable Court. They may be from Germany. That does not mean that they are required to be given any preferential treatment. Then, sir, Mr. Cooper pointed out that though on one hand we say that defendants number 3 and 4 are shareholders, in our plaint we are not describing them as shareholders. So look at paragraph 6 of my plaint. In paragraph 6 of my plaint, we have categorically averred that defendants number 3 and 4 are the shareholders of defendant number 1. So paragraph 6 of my plaint may be just taken note of. So last 3 lines of my paragraph.
No, Mr. Dave, I'm sorry, I'm not clear. What I argued was...
No, Mr. Cooper argued. Mr. Cooper pointed out.
What I argued was 3 and 4 may or, according to us, are not shareholders. The trial court grants injunction against these shareholders who are not there.
But I'll come to that. But Mr. Cooper's contention was...
is not correct. I argued that
you mentioned from first title.
I said you have described them wrongly, knowing that they are not shareholders. Then you have averred that they are shareholders.
Therefore, I'm dealing with that contention only.
This is not.
Not correct. Sir, let me make good my case.
Shareholders, he knows who the shareholders are. And
sir, paragraph number 6 may be seen.
Doesn't make parties.
Paragraph number 6. Paragraph number 6.
He says that people who are not shareholders are shareholders.
But Mr. Cooper, don't get, sir, I know they are desperate. But sir, let me refer to paragraph 6 of the plaint. Sir, paragraph 6 of the plaint clearly shows. Now, where is denial from defendants number 3 and 4 by way of a reply? Mr. Cooper says, where is the requirement of filing a reply to oppose an injunction application? Sir, in my respectful submission, if the facts are pleaded in the application, pleaded in the plain, and if you want to dispute those facts, you have to file the reply. And sir, on one hand, to say that difference number 3 and 4 are not the shareholders,
I'm not talking about
difference
reply.
number
His
3 and 4 are
document
not
says-
coming
his
forward.
document shows that you are not shareholders.
Sir, let
His
me,
research said so.
sir, this is not fair. Mr. Cooper has already argued. I am responding to it because he argued this point for the first time. Sir, number 3 and 4 are specifically and categorically referred to in paragraph 6 of the plain as the shareholders. It is for difference number 3 and 4 to appear and say by filing an appropriate reply that we are not the shareholders. They are not coming forward because if they come forward, they will have to explain their conduct as to how, if they were not the shareholders, their names appeared at each and every stage of the negotiation, including the public notice which came to be issued by difference number 1. Then, sir, it is thought to be contended that difference number 1 and 2 are not at all concerned with this matter. They've been wrongly dragged. Sir, virtually they are arguing the case on merits. If they are not concerned in my respectful submission, then they should not worry about the injunction order. I am happy with the injunction order as it operates against number 3 and 4. Then, sir, it was thought to be contended that principle of the case would not fall because according to my Mr. Soparkar's argument that in the rarest of the rare case,
So this is
Just stay-
beyond rejoinder.
આ તો વાંધો નહીં એમાં. ધવલભાઈ, તો તમે arguments કરેલા.
અમે કરી નાખ્યો સર મારે બીજું સાહેબ નથી સાહેબ last thing. Sir, only last submission. So only last submission. Sir, I will not repeat. My specific case is that my offer of 9th September was accepted without any rider on 20th of September. Communications after 20th September are not for the purpose of concluding the contract, but in furtherance of the contract which came to be concluded. So they were for the purpose of working out the modalities for executing the share purchase agreement and not for the purpose of deciding as to whether share purchase agreement is required to be executed or not. So there is a thick line of demarcation between parties deciding about the modalities of share purchase agreement and parties are yet to decide whether share purchase agreement is required to be executed or not. So in my respectful submission, this is not a kind of case where interference is required at the stage of the hearing of the stay application to grant the stay, bypassing the principle of law laid down by the Honorable Supreme Court in a numerous cases. But now, we'll make our written submissions by Monday. Well, I'll try to.
No, sir. Written submission. will be-
I think બધાનું.
Okay. Sir, my written submissions are ready. I'll give it here and now.
No,
In
now
one-
there is no requirement.
Okay.
All go. હવે કોઈના return submissions, whatever, what you are going to say.
Just to assist your honor, just to assist your honor, if honor says no, we will accept it. Otherwise,
Now,
assist your honor.
we don't require anything now further because
Okay, sir. If it is
already there are too many citations are there. And khali this is only hearing of exhibit 5. So I think now there is no any further requirement of.
please, as your honor pleases. And sir, we are immensely obliged for the
Yeah,
time devoted and the patient
Thank you,
hearing,
sir.
sir. We are our
We are giving it for orders on 25th.
Okay. Oblige, sir.
25th.
25th it is for order now.
Okay, sir. Oblige.
We are immensely obliged for the patient hearing, sir.
અને ધોરભાઈ at the most તમારું maximum એક just મને પૂછ્યું કે you cannot compel anybody to sign contract with you only. You just sell your company to us only like that. It is something like that. It appears from this form.
Oh, sorry, I didn't get you,
Must
sir.
be submitted.
So, sir,
There is only negotiations are going on till the last date. There was
Sir,
a
sir, according to me, sir, therefore I'm saying to say, sir, 9th September was my offer.
but even after 14th, even in the month of November also there was some
So, no, sir, these
negotiations are
were for the,
going on.
sir,
There is
like,
a amended SNP.
no, sir, no, therefore I'm trying to say, sir, it's like this. If I want to sell my house, price is fixed. And then sale deeds, what are the terms to end the sale deeds? These are the model, how sale deeds to be worded. These are modalities for the purpose of giving effect to the decision. So my contract was concluded on 9th, 20th of September. Subsequent events, otherwise, sir, they would not have said, have patience. They tell me that have patience, we are trying to finalize. So finalization of share purchase agreement is not for the purpose of arriving at the contract. Contract is already arrived at. That is for the purpose of implementing the contract.
Sir, page.
Madam Advani, now we are keeping it for order on
Okay,
25th.
sir. Thank you, sir.
25th.
Thank you.
25th. Around 12:30 or 1 o'clock, I will pronounce the order.
Yes, sir.
Please, sir. Please,
Will
Your
you also
Lordship.
permit the video conferencing at that time?
Yes, yes.
Okay.
Definitely.
Thank you, sir. God
Please,
bless.
we are immensely obliged for the question.
Okay.
Much obliged.
Thank
Much.
you.
Immensely obliged. Thank you for a patient hearing.
25th now, 12:30.
I will be here. Respondent number 1 तर्फे वकील श्री कपड़ना जूनियर देवीलाल यादव देवीलाल रिस्पोंडेंट नंबर 2 तर्फे देवांग भाई आचार्य सवारे आवे भले એમના તરફે સોરી ઉપર સાવ છે 3-4 તરફે સ્મિત પટેલ
बस हम बताइए देंगे। सर, उदाहरण है मीटिंग। तो आप ही दे दो। हमारी जोड़े जा। इधर जाओ। I will go now. Because सारा है।